You are controversial. And let's start with that. You're controversial because many of us that have lived our lives as women really recognize the value of finally being able to control our reproductive systems. And Roe entered into that, obviously.
I'm asking what your belief is about the effect of overturning Roe v. Wade. Would you agree with me that it would have a massive disruptive effect on the lives of countless Americans?
Well, Senator, I don't think I ought to express personal opinions for the reason why nominees have drawn that, for the same reason that nominees have given in the past.
When is it proper for a judge to put their religious views above applying the law?
Thank you, Chairman Grassley. Let me start with your very last question and say never. It's never appropriate for a judge to impose that judge's personal convictions, whether they derive from faith or anywhere else, on the law.
I listened to your answers to Senator Grassley's question, and it leaves me a bit puzzled because you have a long history of believing that your religious beliefs should prevail. Let me ask a question. In a 2013 article, you argued that the force of Supreme Court super precedents does not, and this is the quote, does not derive from any decision by the court, but rather because litigants don't challenge the decisions. You listed Supreme Court super precedents, but you left out Roe v. Wade. You suggested that Roe is not a super precedent because litigants continue to challenge it. However, as a textbook co-authored by Justice Neil Gorsuch last year points out, Roe is super precedent because it has survived more than 36 attempts to overturn it. So in evaluating super precedents, why did you solely focus on the fact that Roe has been challenged by litigants on so many occasions, and not on the fact that the Supreme Court has repeatedly reaffirmed Roe in literally dozens of decisions?
Thank you, Senator Feinstein. That wasn't my list. I was addressing arguments that had been made by other professors, serious, well-respected scholars like Richard Fallon at Harvard and Michael Gerhardt at North Carolina, and it wasn't my list. I was quoting them, and I was quoting their definition of super precedent. One thing I would observe is that for a court of appeals, all Supreme Court precedent is super precedent.
Professor Barrett, in a speech that you delivered at Notre Dame in 2013, entitled Roe at 40, the Supreme Court Abortion and the Culture Wars That Followed, you suggested that overturning Roe would have little impact on Americans. You said, quote, the day after Roe fell, of course, abortion would be neither legal nor illegal throughout the United States. Instead, the states and Congress would be free to ban, protect, or regulate abortion as they saw fit. Do you continue to believe that?
Senator, the context of those remarks was addressing the pro-life movement. I'd been asked a question about protests of Roe versus Wade, and I was indicating that I thought that was not, that for those students in the audience who were interested in protesting, I was simply saying, for you, if that's what you're interested in, I thought that it wasn't a fruitful course, a fruitful way for them to think about it. I wasn't commenting on the impact that Roe would have.